welcome everybody to the this webinar on really protecting your IP and grant compliance as you build your research programs. My name is Bobby Mohanty. I am a faculty member in chemical engineering and material science engineering. I'm also a former TLO ambassador, and I've interacted with TLO for several years and gone through the entire disclosure to patenting and getting it issued process. And I've got a few of those that I've managed to get through the system. And it's as you'll hear today, there's quite a few steps that are involved, but the important thing is not only we are required to do it as we develop our research programs, but also it does lead to additional funding opportunities. Chase, could you show that slide real quick? So here's a single slide that illustrates some of the resources that you can get or that are available once you disclose. So that once you disclose an idea, it goes through an evaluation process. But the TLO is really here to help you commercialize and do that technology transfer. And there are a number of grants and funding opportunities that are available. So once you disclose, you have, and you eventually get to your intellectual property, you now have a piece of information or technology that you can use to build technology translation, a business around. And so the general source for those, we have government grants for our SBIR, STTRs, which many of you probably know about. But what a lot of you may not know about is that once you disclose, you have access to a lot of internal grants that can actually help you get there. Maybe you need to build a prototype. So there's these internal grants from the Sender program. There's other internal seed grants for different types of technology. There's faculty small grants. There's also partnerships with venture funding firms. The U also has a venture firm that is designed to help take technology that's funded by, say, the Ascended mechanism to actually building out a small business. So now that is not excuse me. That's for everyone within our ecosystem. Now that's not the topic, the fundamental topic of today, which is more about the disclosure aspect. But we wanted to show you is that this is what you have available to you as you start disclosing your ideas, so you can really think forward about moving your technology to the marketplace. Now, I've a couple things about me. So I've been at the University of Utah for 12 years. My first tech that I got disclosed, issued, and got a rolled patent on was a breath sensitive technology for tuberculosis. I have another one. I went through a similar process that was designed around bioreactors and growing them for biofuels. So very, very familiar with the process. And in general, if any of you ever have a question, you can always reach out to me. My contact information will be there from a faculty perspective if you want to get my thoughts on how you think about going through this process. So for today, we're going to have two presentations. One will be from Corey Bingham, who is the director of intellectual property, and he's going to cover how to disclose the system that we have at TLO, and also some thought processes and things to think about when you disclose. And then after that, Debbie Arnold, who's the associate director of license and government compliance, is going to go over the post-disclosure compliance and things that you have to do. One thing as investigators that I want to highlight is when you get a grant from a federal agency, NSF, NIH, you often may have an idea that you want to disclose or patent or develop more. When you finish that grant, though, you're required to put it in something called iEdison, or actually the TLO puts it in for you. But you need to disclose to the government what ideas came out of the grant. We're required to do that. And we're going to get more details about that today. But a lot of times PIs don't know that. I did not know that when I got my first grant. I learned about it later and obviously complied. But these are some little aspects about this process that are important, and which is why many of you are here. I think with that in mind, I don't have anything else to add. Chase, Corey, is there anything else you'd like me to cover? Or are we ready to go to Corey?
I think we can toss it off to Corey. I'll get your slides up here.
Okay.
Oh, and feel free to put questions in the chat. We'll be monitoring those, and at the very end, we'll try to get to those questions as they come up.
Okay, yeah. So yeah, just to introduce myself again, Corey Bingham, Director of Intellectual Property of the Technology Licensing Office. Thanks for the intro, Bobby. After what he said, one thing I did realize, I didn't put a link to the disclosure portal. Chase or Carolyn, maybe we can send that out just to the attendees after we've done this. We have a disclosure portal on our website, which is the place you'd want to go to be able to fill out a disclosure on any technology. And we try and keep it pretty simple. Of course, there's information we need, but mostly we try to keep it simple to a few questions about who the inventors are, what the technology is, what problem does it solve, and there we go. Carolyn just sent it. Yeah. And any other solutions that you're aware of out there. So we try and keep it to just 4 questions or so. You need to fill out a bit about yourself and if there's any grants and things. But if there's any questions about that, you can see the link, and we're happy to answer anything by email if you want to know more about how to disclose through the portal. So I've kind of divided my presentation here into a few questions. First one being, as you can see, when do you need to disclose your invention? And so early disclosure is the best, is what I would say. We get technologies at various degrees of readiness, various degrees of development. The only really caveat I would say, if it's something you thought of in the shower this morning, maybe you don't need to disclose quite yet. But other than that, earlier is better. And the reason is that we're able to monitor the progress of the project as you continue development and continue research. And really, if we get a disclosure, we're not able to do anything with it because it's too early, we can still reach out periodically. We have a team of relationship managers that interact with faculty and anyone working on a research project. And so we just kind of docket it, and then over time, they're able to check in every few months, see if progress has been made, what data has been collected. So for that reason, earlier is better. And a main reason that earlier is better is because there's, a lot of issues that tend to pop up in the disclosure process. And it's always better to know about them earlier so that we can address them. One of them being grants that Debbie will talk about. There's government reporting requirements and things like that. So knowing earlier allows us to meet the reporting requirements. The big one that I'm concerned about is the one at the top of my little list down there is publications. There's an awful lot that can happen to lose rights to patenting a technology if it's published before it's got a patent application on file. So that's typically what I keep my eye on more than anything, is if there's going to be a public presentation, poster presentation, publication in a journal, and we'll get into that in a little bit more detail. But the main idea here to emphasize is earlier is better. Earlier is better. If there's a technology that's in a pretty good stage of development, then the sooner we know about it, the more we can handle it. So Chase, you can move on to the next slide. And so here's the big question: how do I protect my IP before public disclosure? What I've already talked about, disclose it to our office first. That really is the first step. And then we've got our team who can handle issues as they pop up as we continue along this process. So that's step one. The other step is file a provisional patent application. And so we analyze our disclosures as we get them. For prior art, we want to know what else is out there. So we do a prior art search assessment. We typically do a market assessment of some kind to see what viability the technology will have in the market. And kind of before I do any of that, I just want to make sure that the invention is patentable under current US laws. So I spent my career prior to coming to the U as a patent attorney and looking at different technologies. And so the first thing that happens when something gets disclosed to our office is maybe not the absolute first thing, but first day it's going to come across my desk and I can read the description and see if there's anything I need to do right away and be able to determine if it's a patentable technology. So certain things are patentable, certain things are not. Under US law, software is currently a tricky issue. There's plenty of patentable software, but there's a lot that they consider abstract ideas under Supreme Court decisions, which it's a lot of people disagree with the current state of the law, but that's kind of neither here nor there. We kind of have to adhere to it. But then other things that come across my desk are natural products. Things that already exist in nature are not patentable. They have to be created by the inventors, right? So anyway, the next thing that we always want to do to protect the IP after filing a provisional patent, actually before filing a provisional, is if you have a relationship with a company or with another outside party, we want to make sure that confidentiality is in place. The reason public disclosures we monitor so closely is that once something is disclosed, in certain jurisdictions, you lose patentability right away, but in the US, you have a 1-year grace period. So we want to make sure that we have something on file before a disclosure. And if you're talking with outside parties, we want that confidentiality agreement in place, because then under the law, we won't lose patent rights to any technologies, as long as we have those in place before they're presented. So we can go to the next slide now, and we'll talk a little bit about what counts as a public disclosure. So as I said earlier, if there's a public disclosure before a patent application, it limits patent rights. And so these are the public disclosures that we tend to monitor heavily. This is kind of what we get most that comes through our office. So obviously researchers want to publish this. We want to get it out to the public and start finding collaborators, make sure that we're moving this right along. And our office wants to protect IP, but more than anything, we don't want to hinder faculty efforts, right? Your positions are definitely most important. You want to get it published, you want to get it out there, and you want to start making progress on it. And we don't want to hinder that. So I don't want to, say to you, stop, don't tell anyone, don't present at this conference, don't submit to this journal. What we want to do is get something on file so that then you're allowed to present without it affecting patent rights. So very obvious is a publication, is a public disclosure under the law. And this could be in many forms, through a journal, through online resource. Preprint servers are ones that we run into that can kind of cause problems, because as soon as you upload it, it's a public disclosure. Through the journal process, we have a bit more time. You submit it to the journal, it's not a public disclosure yet, right? There's a review process that's confidential. They'll get back to you as to whether they're going to publish it. There's revisions. There's quite a long process. So it's not a public disclosure in a publication until the moment that they publish it, in whatever medium they do publish it. Preprint servers online or website publications are different, that as soon as you upload it, bam, that's a public disclosure, and it can limit patent rights as of that moment. So if by some happenstance something gets uploaded and you realize, oh, maybe I shouldn't, you can still reach out to me it'd be a bit of a race, but we can speak to our law firms about getting a provisional application on file the same day. So even if you had uploaded it beforehand, as long as something's on file the same day, we can preserve patent rights. So at conferences or verbal discussions with others outside of the university, those are public disclosures as of the date that the presentation is made. Some conferences will publish abstracts beforehand, so we like to know about that too, because if there's something in the abstract that gets published beforehand, we'd like to get a provisional on file before that. But most of the time, we just want to worry about getting a provisional on file before the conference presentation. So that's a big important one. Just let us know and we'll make sure we get something on file before you present. Thesis and dissertation defenses are defined as public disclosures. And one issue that we run into as of the date of the disclosure, sometimes people will come to us and just let us know there was no one at this disclosure other than the student presenting, faculty members, and maybe you know, a few other people who are internal to the university. What's kind of awkward is it doesn't matter, even if we can document that there was only internal people at that defense, it's still a public disclosure. And that's just because they're supposed to be public by nature, right? They can be advertised, and if someone wants to attend it, then it's public, and it doesn't matter if no one public actually attended it. So the classic example they give in the patent laws is that if there's a situation where a book is published, it's only ever given to one library. That library puts it in a back room that no one ever goes to, and the library records can establish that no one ever checked out the book. It doesn't matter. The Supreme Court has decided that that is a public disclosure. So kind of interesting, weird, maybe doesn't make a whole lot of sense, but that is the law as it stands. So grant proposals, I just want to discuss those as well. They're confidential through the whole process until the funds are actually awarded for the grant. And that's the reason for that is taxpayer dollars are involved, and then it becomes discoverable through a Freedom of Information Act request. So that's the reason why it's confidential through, you know, if you've submitted a grant or have a grant proposal, we're good up until the point that it funds. And sometimes that can be a bit unexpected and a bit quick. So we try and get something on file before that happens. Hopefully funding agencies would let you know before it actually grants. Hopefully we have a date, but sometimes we got to move pretty quick, but we'll get a patent application on file before that. Chase, you can go ahead to the next slide. Okay, so I've already covered a little bit of this, but we'll go into it a bit deeper. Can a patent still be filed if a disclosure has occurred? Like I said before, if there's a disclosure, we can still get something on file the same day to protect all patent rights. The United States gives a 1-year grace period. So even if you said, oh, you know what, I presented this 2 weeks ago or a month ago or 6 months ago even, we can still get a US patent application on file. So that's good. That's really good that the laws give us that 1-year grace period, because it has saved some technologies in the past and really gives us a nice bit of breathing room in case we need to file something. But for most international jurisdictions, the moment it's disclosed, we've lost the right to file a patent application internationally, which is unfortunate. Mostly what affects us there is it's harder for us to market the technology to outside partners and harder to get a licensee who's willing to license it, take it to market, and then you know, make money off of it. So we like the best when we get a disclosure prior to any sort of presentation or publication. But if, you know, if the cat's out of the bag, but we're within a year, let us know, and there's something we can do. If it has been presented more than a year ago, then the laws deem it as handed over to the public, essentially. We can't do anything with it after that point. and it just kind of has to be public domain. But hopefully we can avoid that scenario, but that is kind of the worst case scenario. You can move to my last slide, Chase. Okay, and then just for anyone who didn't know, I speak a lot about provisionals and non-provisionals. Some people know the difference between, but a lot of people don't. So hopefully this won't be a review. But provisional applications, the reason we can move so fast on them is they're informal. Like if you have a manuscript, or if all you have is a PowerPoint, or if what you have is a poster, we don't need to do anything with it. I hand it to the law firm. They can file that with the PTO without any really modifications being made, and that will hold our spot in line for the technology. And it's good for whatever's in the poster, right? Whatever's in there has been presented. We've got the priority ahead of others for patenting that technology. So it's better to have a more detailed provisional, because the more detail you have, the more protection you have. But, you know, if we need to move quick, something's better than nothing, and it can be very good at protecting the technology. So provisionals really are just a placeholder. We just put a line in the sand of when we have a date of when we were in possession of the technology, but they're never looked at by the patent office. They're never published. They have 1 year in which we need to file a non-provisional application to keep moving forward with the technology. And the non-provisional is where we get the law firm to start drafting something from the ground up based on any of your materials, manuscript, grant proposal, poster, or other presentation materials. And they will draft it in the formal patent application format, file it at the USPTO, and then from there, it's just a waiting game for the USPTO to get to it. They'll give us rejections, which happen all the time. Sometimes people are upset when we get a first office action from the patent office and everything's rejected. That's really par for the course. Almost every single first office action we get, there's rejections, but we're allowed to amend, make arguments, and move forward after that. So most things, you know, not all the time, but a lot of things can end up getting patented, even if we get a big ugly office action right out of the gate. But so just to sum it up, the provisionals really help us to protect your technology if there's going to be a public disclosure, and we can get it real quick and dirty on file at the patent office, and it protects us. And then we have a whole year to check in with you, see what development is being made, and see how the technology progresses before we file a non-provisional a year later. And so that's kind of the process that I go through. I'm sure that there'll be a few questions we can get to at the end. I saw a couple pop up in the chat, and we can get to those at the end. But for now, I can hand the time over to Debbie for her presentation. So let me switch your spots.
Sharing computers here. So my name's Debbie Arnold, and I've been with TLO for about 10 years now. I've done government reporting for 9 of those 10 years. And it seems like every year there's something new that I'm learning about the government. So with that in mind, I'll share with you what I know. Next slide. So I wanted to go over a little bit about why Bayh-Dole matters. Before Bayh-Dole, every patent, every technology, every idea that small businesses and universities came up with were owned by the government if they were first conceived or further advanced using government funding. Based on that, universities didn't move forward with commercialization. There was no incentive to do that because everything was owned by the government. Approximately 30,000 patents sat on the shelves collecting dust at the USPTO because nothing was ever done with them, being owned by the government. In 1980, Bob Dole and Birch Bayh got together and worked very closely with Stanford University to come up with a bipartisan act known as the Bayh-Dole Act. This act allowed the small businesses and the universities to maintain ownership of any of the patents and technologies that arrived from federally funded grants and funding. It gave us the right to retain the title based on the requirements that we're going to go over now. Next slide. So first of all, does your invention fall under the requirements of Bayh-Dole? So the first bullet point I have there explains if it falls under Bayh-Dole. Okay, but one of the questions that I wanted to address is I get a lot of faculty or inventors coming to me and saying, well, my grant was only used to pay a grad student. That's the only thing I used the money for. Okay, but if that grad student worked on this technology, either when it was being conceived or if it was further reduced practice, then it falls under Bayh-Dole, and that grant should be included in your technology when you disclose it to our office. Software, other digital inventions, they only fall under Bayh-Dole if it's patentable. So that gets a little bit, whether it's patentable or not, we have to dive into a little bit further. But copyright matters, they do not fall under Bayh-Dole. They are not subject because they are not patentable. Next slide. So what is our office's role in meeting the Bayh-Dole requirements? One thing that I do not have listed here because it's not really our role, but it's your role. In 2018, Bayh-Dole was a little bit revised, and one of the revisions was that every faculty member has to sign an employee assignment agreement, which is something you do with HR, assigning all rights to the invention and patents over to the University of Utah. So before we license anything, we're going to confirm that all of that has been done, because if it wasn't, then we're in trouble with Bayh-Dole. After a technology is disclosed to our office, I have 60 days to notify the agency that it was disclosed. So the information that Corey just reviewed on what we're going to review with you once you disclose a technology, it's important for you to put a priority on the requests that we give you. Can we meet? Can we discuss the technology? Can we review the grant information? All of that stuff needs to be kind of closed up within 60 days so that I can get it reported to the government agency if federal funding was used. 2 years after we disclose it to the agency, I have, and that's disclosure to the agency. So not 2 years after you disclose it to our office, but 2 years from when I disclose it to the agency. We are to elect title. And by electing title, what I mean is we are going to make the determination whether we can patent that technology if we haven't already, and whether we're going to move forward in trying to get it licensed. 1 year from election, we need to file our first patent application. Now, this is all caveat to Corey's comments on, did you disclose? If you disclosed it to the public, then that all falls back to that year that Corey explained. We've got a year to cover it. That also falls under the Bayh-Dole requirements that we need to do it in a year versus these prior commitments that I mentioned above. We also have 60 days prior to abandoning a patent to let the government know. Now, this was something that was just recently changed in 2018. Technically, we have to file a non-provisional from a provisional in 60 days. Our office and technology transfer offices across the United States do not file that early, a non-provisional from a provisional. We like to wait closer to the deadline of the provisional. So I can request an extension if we know we're going to file a non-provisional. I can request an extension from the agency to file the patent when the provisional patent is expiring versus 60 days before. But the reason we have to give them 60 days is because the agencies want that 60 days if we're not going to go further with a provisional patent or divisional patent for some reason. They want the option to be able to move forward themselves. Never known them to move forward themselves, but they have that option. The last thing that we're required to do are yearly utilization reports. And effective 2023, the utilization reporting got a lot more detailed. We're required to advise if it's licensed, and if it's not licensed, what are we doing to move forward to get it licensed? And typically what that means is the inventors are moving forward to try to get more patents on it. They're working at maybe getting an SBIR, STTR, or some kind of funding to move forward with the invention. Once it's licensed, we report, is it non-exclusive or exclusive? If it's non-exclusive, how many non-exclusive licenses? If it's licensed, has a product been sold? And this is really important in today's environment because licensees are not permitted to manufacture overseas without a manufacturer's waiver. So when I report any products being sold, which are reported to our office from a licensee, I also need to collect what is the name of the product, what is the name of manufacturer, and what is the state that the product is being manufactured in. And if it's not a state, then we have a problem, because if we don't have a manufacturing waiver, we've got a problem under Bayh-Dole. Next slide. So what we want to do is protect the university's patent rights. Now, the first two items that I explained were reporting within 60 days and title election within 2 years. If we do not meet those deadlines, the government agency has the right to take title to the patent and to the technology for the life of the patents. So those are two very important deadlines that we want to meet. Again, it's important for you to work with our intake process to get the review finalized so that it can be reported to the government within those 60 days. Other than that, when Corey files for patent rights, we need to make sure we have a government support clause, and it's very specific, the exact wording that has to be in the patent, stating that the government did have some help funded the technology and patents, and they have certain rights to it. We also have to sign a confirmatory license, which is a non-exclusive license for the government to utilize the patents within the government only. The first two are the ability for the agency to take title if we miss those. Further on, then there's a thing called march-in rights. And this has been attempted many times. And now this is it's kind of hard because right now the political environment, everybody knows about what's happening with Harvard. I don't know how that's going to turn out. I don't think anybody does, but let's just go under the rules of Bayh-Dole for right now for this presentation. They can, we've had several special action people that have been trying to get march-in rights taken from universities or licensees based on pricing. It's never gone through. Technically, what has to happen is if the government marches in and takes a non-exclusive license to any patents, then the government has to go out and source licensees to manufacture it. There was one particular march-in request where a manufacturing was not getting enough of the medication manufactured to get out to the patients that needed it. The government reviewed what was going on with that, and the government determined that they could not, the manufacturer put in place specific steps on how they were going to get it corrected. And based on that, the government agency determined it was NIH, which NIH is most of them. They determined that they could not get it licensed and get the manufacturing started and the testing that was required to get the product or the medications out to the public any faster than what the licensee could. So they did not initiate march-in rights for that particular incident. Making sure that we report everything under the requirements of Bayh-Dole enables our office to get licensing and commercialization. one of the very first thing our contracts team does is come to me and say, are we in compliance with Bayh-Dole under these technologies and patents before we actually go out and license the technologies. We don't want to license something if it's not in compliance. And it helps the universities fulfill obligations and attract future funding. And what I mean by that is every year Congress has, or agencies have to go to Congress and say, we had this much money last year, we want this much money, and here are our reasons for wanting this much money. And they're going to advise Congress how much of the money produced medications, medical devices, whatever, to help the public. The whole thing on government funding is what can we get out to the public to make their lives better? And so the more that we disclose to the government as that we're working on technologies that were funded in part by the government, attracts the ability for the University of Utah to get more funding from the government. So you always want to make sure when you disclose, let us know if there was government funding, because that's only a positive outlook for the agency to look and see that we are actually doing something with the money they're giving the university. Next slide. So best practices, as Corey said, disclose inventions to TLO promptly. Keep clear records of funding sources. I know that this is, I don't know because I'm not in your shoes, but I understand it's very hard to keep records of exactly where all the sources for the funding were allocated to, but it's important to keep those clear records and work with us early for IP protection so that I can make sure I get government support clause in the provisionals when they're filed, and that Corey can get those on file for you to protect your inventions. I think that's all I've got.
Thank you both. I think there's just been 2 questions in the chat that were answered in the chat, but maybe we can just touch on verbally for everyone here. And then if everyone else has any other questions, throw them in the chat now and we can kind of monitor that. One of the questions, Corey, as far as timing goes, should a provisional be filed before publication or even before that? And then he gave a couple examples if you have the chat visible as well.
I do. Yep, I see it. It looks like Bobby answered it too, but it's correct what Bobby said, but I'll go ahead and just throw in my 2 cents as well. Yes, it would need to be at least filed before publication. That's the most critical date to get it on file. The peer review process, I think, is probably the best, just to make sure that you're in contact with our office so that we know how it's proceeding. When we have a date of publication, that's what I really like to know, because then I can go to the law firm who's preparing the application and just say, it's going to publish, about this day. We need to make sure we have it on file before then. Yeah.
Perfect. And then there was a earlier question at the beginning that I can touch on of people were asking, I think related to the funding and programs of whether it's for students, founders, or just faculty. And the answer is that there's programs for all. So there's programs that will support students. And, for undergrad students specifically, Lassonde Studios might have more programs focused, but then graduate students, postdocs, PhD students, it varies kind of by program, but there's definitely support that the TLO can offer there. And so it's kind of a case by case, but we've got programs and opportunities that support all different, whether you're external kind of companies that are licensing or internal. So, and if you, with the theme of this webinar, disclosing something to us, we'll help work with you. And, at the end of the day, a disclosure is a formal way that launches all of our support and help here at the TLO. So I don't see any, additional questions. So I appreciate everyone for your time hopping on this. We'll post the recording and send this out to everyone. And thank you, Corey and Debbie and Bobby, for your guidance on this session.
Chase, I think we got one more on Bayh-Dole just came through.
Yeah.
Yeah.
Oops, what are the, okay, so the question is, what are the rules for IP that was created under funding from the state of Utah? I can't answer that question because that's, when I talk Bayh-Dole, I'm talking government funding, but I'm not talking state. So when we get a grant from the state of Utah, I review every one of those awards to see what the specific requirements are. And this goes as the same way with foundations. When we get a foundation grant, I pull the grant from OSP records and I reviewed it to see if there are any requirements from our office. I don't worry about the requirements of the faculty or the inventor, but whatever's required from our office to report, those are something that we take into consideration and make sure that we meet the requirements. And there's another question here. What's this one?
Yeah, let me see. The benefits and requirements for founders, companies working with the university, working to create university IP as opposed to working on it yourself.
I think they're referring to the stuff I covered briefly in the beginning about those opportunities.
Oh, right. Okay. Yeah. And what I can say, I don't know if I have the full answer to this, but maybe something, Office of Sponsored Projects could weigh in on. If there's founders or companies sponsoring university IP, typically there's terms of option agreements or co-ownership. I'm not familiar with all those. I apologize. I can't give maybe a full answer to that question. But if there's a company or outside entity sponsoring research or creating IP with the university, typically I think Office of Sponsored Projects would be able to work out terms of sharing the IP or something like that. But
Right.
I
And
don't know if you
I
have
can
more.
tell you from personal experience that's what happens. So, and typically also that company has the exclusive license to take the tech and commercialize it. And before anything happens, an agreement is worked out to figure out how that IP is owned, usually is co-owned, and how and who foots the bill for the patent costs, which is one of the big things that are a big deal. So those are all worked out prior to execution of the project. So we have a couple of projects that are done exactly that way. In our case, the IP is jointly owned between the entities and the U.
There you go.
You're muted, Debbie.
One of the things that I wanted to mention, when we get a technology in, I'm going to take a look at the grant number and I'm going to pull that up. If it's an NIH grant, I'm going to pull it up in NIH Reporter and just verify that that was awarded to the University of Utah. Many times I'll find that it was awarded to another university or even to maybe a company that they've given us a subaward to. So sometimes the intake team will come back to you and just verify, did we get a subaward for this? Because the grant wasn't awarded to the University of Utah. And then that goes into what Bobby had just mentioned, whether we need to get an IIA, an interinstitutional agreement put together, who's got the rights and that type thing. So those are all things that our office does review when the technology is disclosed to our office.
And then I saw another question here from Vanessa. I can answer this one. So if you file a provisional patent but run out of time before converting it and you haven't published any data, can you refile the provisional with a new disclosure date to extend the protection for another year? The answer to that is yes. If it has not been publicly disclosed and it still remains confidential within the university, we've done this several times, although there might be Bayh-Dole considerations, right, Debbie, with this. But under patent laws, it is possible if a provisional expires and you just say, I don't have the data to back this up yet, we can let it expire and file a new one, subject, of course, to the Bayh-Dole that Debbie can talk about right now.
And if we do that, what I'm going to do is go in IATIS and say, we're waiving this, we're not going to move forward on this provisional, but we are not waiving our rights to the provisional. And I will request an extension for filing a non-provisional against the provisional patent, which typically is always approved.
Yep. And Kai is absolutely correct. Kai put in the chat, but don't you lose your priority date? You do. That's right. So the earlier priority date lapses, you don't have that anymore. And there is a risk that if someone has invented the same thing in the meantime and filed a patent earlier than us, then we run the risk of losing the ability to patent it just because they beat us to the race. So I'm glad you brought that up. That's a very important consideration. There's always that risk. And that's why we like to not do that if we don't have to, but you know, if it's not matured enough to a patent, then we can roll to another provisional.
Awesome. Well, I don't think it looks like we have any additional questions. So again, appreciate the time, everyone. If you have more follow-up questions, always reach out to our team here at the TLO. We're happy to help and assist. And again, we'll send out this recording and meeting summary within the coming days. Thanks, everyone.
Thank you.
Bye.